Good day, everyone, and welcome to our webinar today entitled House Rules, Understanding Property Ownership, and More, brought to you by the Philippine Daily Inquirer's Property Section in partnership with prime property developer Ortigas Land. I am Tex Samaniego, editor of the Property Section of the Inquirer, and I will be your host today. Article 3 of the Civil Code of the Philippines states that ignorance of the law excuses no one from compliance therewith. Indeed, we cannot run away nor hide from the law, as law affects all aspects of our daily lives. It is highly crucial for every home buyer, investor, or property owner to understand the various procedural laws and administrative rules that could guide them in their transactions. In particular, having at least a basic understanding of the complex system of laws on property ownership, real estate transactions, and other similar legalities may help spare one from further headaches and lawsuits. After all, how many times have we seen property ownerships and investments ending up in court and becoming subjects of many legal battles? In today's discussion, we hope to share with you, our viewers, the basic rules and laws governing property acquisition, ownership, and transfer. By the way, feel free to send in your questions throughout the webinar via the comment box below, and we'll try to answer as many as we can. Now, let me introduce to you our first speaker, Attorney Maria Soledad de Riquito Mawis. She is a regular columnist of the Inquirer's Property Section, Dean of the College of Law of Lyceum of the Philippines University, a trustee of the Philippine Association of Law Schools, and founder of the Mawis Law Office. Through her column, Property Rules, Attorney Mawis provides readers information, guidance, and possible legal remedies concerning their property ownership by giving examples of actual cases. Welcome and pleasant afternoon, Attorney Mawis.
Good afternoon, Dec. I hope you're okay and COVID-free up to now. Okay. I would like to thank you for inviting me to join this webinar. You know, parting with your hard-earned money for the purpose of buying a real estate must be a product of a discerned act, not of whim or impulse. So it's really very important for us to know even the basic rules when buying a real property. In fact, even our own Supreme Court in the case of Pudadera versus Magallanes said that a real estate buyer must exercise ordinary care in buying real estate. Hence, it's very important for would-be buyers to know even the basic or rudimentary laws on buying property.
Thank you for that, Attorney. You probably have a few questions you want to ask Attorney Mawis by now, but we'll get to that later during our Q&A. For our next guest, we have Attorney Isagani Elias Elasio, a law graduate of the University of the Philippines. He obtained his Master's of Law degree in International and Economic Business Law from Kyushu University in Fukuoka City, Japan. With over more than a decade of experience in the field of law, he has also worked with several esteemed companies and organizations. He is currently the legal manager and head of external affairs of Ortigas Land. Welcome, Attorney Gani.
Good afternoon. Glad to be here.
So this afternoon's discussion, I'm sure, will be a pretty interesting one for our investors and home buyers. To start off, clearly understanding the basic laws, rules, and legal remedies in home and property ownership is crucial for those looking to grow their investment portfolio. So to start off, we now have a few questions here for all our panelists. But let me throw in the first question. Dean, as a first-time investor, what are the basic legal rules and regulations that I must study and understand? I mean, what basic legal papers must I secure to ensure a worry-free and a smooth transaction?
Okay, may I be allowed to share my slides now, please? Okay, we have to first distinguish what property are you buying. Is it land and then, of course, the house built thereon? Or is it a condo unit? Because the requirements will be different. Okay, why? What will be the checklist if you're buying a land and a house built thereon? First, you have to confirm the existence of the title. Where do you go? You go to the Registrar of Deeds. Try to get a certified true copy. Number two, you have to check whether the title with the Register of Deeds shows any burden, any lien annotated on the title. Because if there is an annotation or lien or encumbrance, then you know you're buying the property with the said encumbrance. Okay, the title therefore is not clean. Third, and very important, is you conduct an ocular inspection. You check the land, you check the description, you check if there's a person occupying the said property. And most importantly, you have to deal only with the real owners. Now, if the owners are spouses, it is very important that it is not only the husband you're dealing with. You have to deal also with the wife. Because if it's only the husband who will sign the deed of absolute sale without the consent of the wife, then the sale will be void under the family code. Okay? So you want this to be a valid agreement, deal with the registered owners. Now, of course, some owners are not here in the Philippines. For example, there is special power of attorney that might be shown to you. Well, it's still, even if a special power of attorney is shown to you, it would be best if the SPA is annotated on the title. If it's not annotated on the title, please deal with the principal. Find means and ways to deal with the principal. And of course, you have to check whether the annual real property tax is up to date, because it has to be up to date in order that you will be able to transfer the property in your name. Now, what if the property you are buying is a condominium unit? Okay. Now, if you're buying a condominium unit, what will be your checklist? I think the very first thing you have to do is check the reputation of the developer. Go into the business history of the developer. Is this developer, can they really finish, or is there a track record about the development, let's say, of a condominium unit? You also check on the broker. Check whether the broker you're dealing with is a licensed real estate broker. You also check basically not only the purchase price, you have to check the fees you have to pay, such as association dues, real property tax, membership fees, realty tax for the common areas, and the parking fees. Expect the unit. Be clear with your needs, be clear with your wants. Because when you're buying that unit, it has to be something that you like, okay? And of course, and most importantly, the payment schedule if you're not going to pay in full. And it is a must that you must review the contract. So those are the things that you have to take in consideration if you're buying a condominium unit. Okay. Also, okay, so basically that's it. Okay, for what will be your checklist for buying a real property.
Mhm. Attorney Gani, let me do a follow-up on that. In the case of Ortigas Land, I mean, what are the requirements, the legal requirements, the legal papers that you usually would ask for any investor or home buyer?
Well, it's essentially the same thing. I think Attorney Mao's slide presentation actually covers everything. For condominium buyers, the checklist would be uh, exactly as what Attorney Mao said. It's pretty much important that you know the developer that you're dealing with. I think that's square one. Uh, in fact, I was thinking while Attorney Mawis was presenting her slide, was that, well, the guides that Attorney Mawis was presenting is actually similar to that of what you would need to look out for in a romantic relationship. You actually would need to know the person that you are dealing with. In the case of real estate, you need to know the company that you're dealing with. Of course, there are top of mind companies out there. Parang that already gives you some comfort. I would like to think that my company, Ortigas Land, is one of those companies, but we're not the only one. In fact, there are other companies that are bigger than us. That is the first thing. I'm not saying that if the developer or the real estate developer, the company that is promoting a condominium unit or a townhouse is not so well known, then you should be careful and you would rather not deal with that. That's not exactly the case. All it needs is you just have to do your due diligence. Check out the person who you're talking to. Is she really a representative of the company? Another thing that Attorney Mawis actually also said, which is very, very important, and I was happy when she mentioned it, is that you check the credentials of the broker that you're dealing with. Because once these things are cleared to your satisfaction. You know that you're dealing with a genuine, legitimate land development company, whether it's a big company or a medium-sized company or even a small company, for so long as you know that their business is legitimate. Once you're assured that, or you've assured yourself that the broker that you're dealing with is legally and legitimately connected to the developer that you want to buy a condominium from, then that puts your mind at ease, and you can now concentrate on the other things. I would also like to reiterate what Attorney Maui said. You check the payment schedule. It is important because you want to have a realistic idea uh, as to what your budget is. You do not want to bite off more than you can chew and everything like that. Um, there is this perception probably that a lot of brokers out there, real estate agents, they only care about selling you uh, the unit, selling you the condominium unit, or selling you the townhouse. And but one of the indicators that you're probably dealing with the right person is if that broker, that real estate agent, actually takes the time to know what exactly are you looking for, what is your budget, then maybe I have a product for you. Then that means that that agent took the time to size up you as a customer and try to at least think about what would be the product that they have that would be appropriate and fit to your budget. Once you're able to find a real estate broker who is like that, then it takes away a lot of headaches and you can concentrate on all the legal matters. With respect to the review of the contract, sometimes, of course, it's a bit tedious, but as a fellow lawyer, I would then also have to agree with what Attorney Maui said. Always review the contract. If you do not understand something like that, it never hurts to ask. As Filipinos, as Asians in particular, sometimes there is this reluctance to ask questions because you do not want to come across as ignorant. You might see it as a bit embarrassing to ask questions. For us, it's not. For most legitimate real estate developers, and if you're talking to a seller who is genuinely interested in selling you a good product, they would take the time to answer any question you may have around the contract. And it is very important for you to understand the provisions there. A contract does not only contain the rights of the seller or us, the real estate developers, but it also contains your rights as a buyer. And that is something that you need to have a good idea of before you plunge into buying it. Attorney Maois also actually said something very important. In a person's life, there will be very few big investments that a person would make. For guys, a lot of it would be cars and everything like that. But for you, and sometimes it's even a family decision, buying real estate is a very, very big step. And you do not want to waste your money like that. So all of the things that Attorney Maui said, check the company that you're dealing with, check the broker, review the contract, have a realistic idea of what your budget is, and you would more or less be in a good position to plunge into that game of buying real estate.
Thank you for that. Usually, when we go into property investment, the first person that we deal with are normally the brokers. Um, if I pay through my broker, I mean, are there actually limits to what a broker can do for me in terms of the transactions? I mean, what are the limitations po, Dean?
Let me just reiterate what I said earlier, that it is a must that you should only deal with the licensed real estate brokers. So before buying the condominium through a broker, verify if the broker agent is registered with the HLURB or DTI. You know, there is this new law called RA 9646, which is actually Real Estate Service Act of the Philippines. And under Section 26 of that law, okay, the law provides that no salesperson shall be entitled to receive or demand a fee, commission, or compensation of any kind from any person other than the duly licensed real estate broker. who has direct control and supervision over him for any service rendered or work done by such salesperson in any real estate transaction. Why did I have to flash that? Because before you part with your money, you better make sure that the person you're dealing with, okay, is really a duly licensed real estate broker. So that if in the remote possibility, this real estate broker absconds with your money without turning it over, okay, to the developer, for example, you can file an administrative case against him to have his license revoked. Then you can also file a criminal case against him or even a civil case against the said real estate broker. So it's really very important for you to be able to know and verify. All you have to do really is ask for this person's ID, okay, yung PRC ID. And then if they can show you that they have a PRC ID, then you can presume that this person already passed the board exam and he is a duly accredited and licensed real estate broker.
Dean and any of you can answer this. In the event that I would pay my dues or my monthly amortization through my broker, because let's say I'm away, I'm abroad, and then suddenly she disappeared, can I sue the developer or the broker?
Panyero, you first.
Well, please forgive me, but this may sound as a cop-out, but it actually depends on the situation. With our experience as a real estate development company is that when the payment has begun, which assumes that you've already executed the contract to sell, and you've chosen the unit that you wanted to buy, you've gone through the preliminaries, you've executed the contract to sell, and you've begun your monthly amortization payments. In most cases, based on our experience as a real estate developer, the broker is actually already out of the picture, so to speak. In most cases, what would already be happening would be that you've already set or agreed with the real estate company on the manner by which you will pay your monthly amortization. There are several versions out there, or there are several schemes that all of which are okay. They have their own respective advantages and disadvantages, and you would just have to find what is best and suitable for you. A common one would be you actually would already, upon signing the contract to sell, be providing the real estate company with post-dated checks of your monthly installment. So in which case, in such situations, the broker is already out of the picture. In the event that for whatever reason, you are actually paying your monthly amortization through your broker, there are certain assumptions that we as a real estate developer have already made, or we've actually probably traced it. We, of course, would prefer to deal with the buyer directly when payments are concerned. But if for some reason you are not able to do that and you've designated your broker as a representative, and you've armed that broker or that real estate agent with a written authority, the most common of which is an SPA, to make those payments for you, and that therefore your money comes from you to the real estate broker at umaabot sa amin, then in such a situation wherein he absconds with the money, then the real estate company does not have any liability for that. Because we actually prefer to deal with you, but you designated someone else to pay on your behalf. However, like as I said from the very beginning, it depends. There might be certain permutations, as Attorney Mawis might actually also confirm later. It depends on the facts of the case. If what happened would be that the money is already with us and it is on our end where the money was lost or was not accounted for, then of course the real estate development company may be liable for it, and you can sue the real estate developer in such a situation. So that would be the case. Of one thing to add na lang is that if ever you're going to pay through someone else, you're actually not limited to designating your broker as the person who will pay your monthly amortization. You can actually designate someone else who you can trust or who you trust more. So that situation would be more likely in today's scenario, especially in situations wherein what you're buying is a condominium unit from real estate developers like us. Attorney Mawis, you may
Yes,
want to add something.
I totally agree with Attorney as regards to what you said, Gani. No? I don't want to call you Isang Gani. It sounds so formal. I'll call you Attorney Gani. Okay.
Thank you.
You know, the very first thing I think you have to do when you are paying, pay to the right person. And who is the right person? The right person is the seller. In this particular case, for example, the condominium developer. You issue a check in the name of the owner of that property. You don't issue a check in the name of the broker. Even if the broker has been duly acknowledged by, let's say, the condominium developer, you still have to pay and make your check payment addressed to, okay, the developer. Now, if you're paying in cash, that's going to be a very sizable amount, okay? So if I were you, go to the head office and pay to the executive officer if necessary. You just don't give your money to any Tom, Dick, and Harry who flashes before you a PRC ID. In other words, you have to use basic common sense in order to protect yourself. Okay, so that's number one. Number two, when you know, I really agree with Attorney Gani in the sense that I have yet to meet a duly authorized real estate broker that would demand that payment be made in their names. If that will be the case, you have to think twice if you're dealing with the right person, especially if, as I said, the unit you're buying is, let's say, being developed by a reputable company, okay? Because they will not never authorize a real estate broker to demand from the would-be buyer, okay, that the checks be issued under the name of the real estate broker. So sometimes it's really more of knee-jerk reaction. Your common sense would really guide you, okay, in making sure that this person will not pull a fast one over you. So basically, and then of course I reiterate, this is a club of mutual admiration. I agree everything in total with what Attorney Gani said earlier. Okay.
Attorney Gani, just a follow-up question. In your case, you don't provide your in-house brokers with like provisionary receipts, like whenever they would receive payments, check payments from your buyers.
That's a very nice question, Tech, because it allows me to clarify certain things. One is that real estate brokers, there can actually be several situations. You might engage a real estate broker to look for a property for you, in which case the real estate broker is representing you, the buyer. And in that case, essentially what you will be doing is you're authorizing that broker to deal with us, the real estate development company, when you're buying a unit or if you fancy a unit in a development that we're constructing. Now, in most situations, however, the most likely scenario that people out there would encounter would be that you are talking to a real estate broker of the real estate development company, because we have a sales force which we also engage real estate brokers precisely for that. In which case, I'm going to be a bit technical here. The legal relationship would be that broker is not representing you, the buyer, but rather that broker is representing us, the real estate company. So essentially, ang may legal ties would be the company and the broker. Now, going into your question as to whether or not we provide real estate brokers with provisional receipts, that is not a common scenario, at least for large real estate brokers, the major players in the industry. Because as I go back to the first point, most of the time, we prefer, and as Attorney Maui said, we prefer that payment go directly to us, the development company. So in terms of payment, the most ideal scenario, and this will be your guide in getting a sense of whether or not you're in the right place, is if you're dealing with the real estate company directly when you're talking about payments or monthly amortizations. And just to add to it, to probably cap it, uh, real estate brokers, they earn through commissions on completing the sale. In most cases, when real estate brokers of the real estate company have been able to convince you to buy from us, and you already executed a contract to sell, they basically earn their commissions there. So Attorney Mawes is completely correct. It is a red flag if you have a broker somewhat insisting or even hinting that your monthly amortization should be made through them. That is probably best avoided.
But Attorney Mawis, I also have another follow-up question. You mentioned that it's not right and it's not proper. But what if I've already developed a very good relationship with my broker and by some chance I gave her my payment and she was able to issue me a provisional receipt, but it's a fake receipt. Do I still stand a chance to file a case in court against the...
Definitely. You can file she can be held criminally liable for misrepresenting herself to you. Yes, but the question is earlier, how can you protect yourself? So the best way to protect and avoid litigation in the future is don't pay to the broker, okay? The check must be in the name of the seller, not the broker. Yes.
My next question would be, I think this is a very common problem now. If I am married to a foreigner, am I actually allowed to own a property in the Philippines? And I mean, is it going to be conjugal property? What are my limitations? Either Dean or Attorney Gani can answer that.
Okay, I'll go first. Girls first this time. Okay. Now the basic question is, if you have a foreigner partner, can you invest in a property in the Philippines? Again, I will have to distinguish what kind of property. If we are talking about private lands, okay, there is this constitutional provision, which is actually Section 14 of Article 14 of the 1987. I'm so sorry, that's not 1973. This is supposed to be 1987 Constitution. Save in cases of hereditary succession, no private land shall be transferred or conveyed except to individuals, corporations, or associations qualified to acquire or hold lands in the public domain. So let's say if I buy, a property somewhere in Quezon City, if I were married, let's say, to an American citizen, I can buy the property because I am Filipino. But that property, even if we're married, will be my own property, my paraphernal property, regardless of whether I was married before or after the effectivity of the family code. Because my foreigner husband cannot own any interest on the real property that I will be buying or I bought, because precisely of the constitutional prohibition. Now, but if we talk about condominium units, okay, condominium units, for example, what will now be the rule? Okay, condominium units, according to the case of Haltz versus PR Builders Inc., foreign nationals can own Philippine real estate through the purchase of condominium units or townhouses constituted under the condominium principle with condominium certificates of title. In fact, this particular decision that was promulgated by the Supreme Court further says the law expressly allows foreigners to acquire condominium units and shares in condominium corporations up to not more than 40% of the total and outstanding capital stock of a Filipino-owned or controlled corporation. Under this setup, the ownership of the land is legally separated from the unit itself. The land is owned by a condominium corporation, and the unit owner is simply a member in this condominium corporation. As long as the 60% of the members of this condominium corporation are Filipino, the remaining members can be foreigners. And in that case, if, for example, I'm married, let's say, to an American citizen, we buy it, okay, in the absence, of prenuptial agreement, that property, depending on when we were married, let's say I was married after August 3, 1988, there's no prenuptial agreement, then that property will form part of our absolute community property. But if the property was bought, okay, prior to the effectivity of the family code, okay, again, in the absence of a prenuptial agreement, then the default property regime with respect to that condominium unit will be conjugal partnership of funds. So it's going to be a conjugal property. So I hope I was able to answer your question.
So then, does the same rule actually apply to all the developers, or does it actually differ? Or the only difference is that if you're acquiring a house and lot, you cannot actually own one. But if you're buying a condo, you can.
Yes, that's the reason why we have to distinguish what property are we talking about. If we're talking about a land, let's say in Valle Verde, okay, that foreigner husband of mine cannot be an owner of that property because it's a private land. So it's when I buy, it's going to be me who will own it to the exclusion of my husband. No, that's going to be my paraphernal property. Or if I'm under what you call absolute community property regime, that will be a reserved property. But when we buy, let's say, a condominium unit, as long as the ratio of 60-40% will be retained, both of us can own. Both of us can own.
Thank you.
Technically, we're not buying the land.
Mhm. Thank you for that, Dean. Now, Attorney Gani, this is one very common concern of most investors. What is perpetual ownership? This is something that every condo investor is actually or would actually want to understand. Does this mean that you are only limited to reside in that particular development for 50 years? Is that really the standard?
I think Attorney Mawis would agree with me when I say that there is no such legal animal as perpetual ownership, although I am very much aware that that term is being used a lot, especially with respect to ownership, in the industry of buying and selling condominium property. In essence, for so long as you bought the property, you own it. And what is, to put it very, very simply, when you buy property, you own it subject to certain limitations of course, with respect to the rights of other people. You can do with it as you wish, and you can stay with it as you wish. I think we have our suspicions as to the concept of staying only there for 50 years has originated from. This is partly because I think that there is prior to recent changes in the corporation code, corporations have a legal life of 50 years. And when a condominium building is put up, and then later on all of the units there are bought, what happens would be that the developer is obligated to set up a corporation or a company that would essentially be the managing company that will manage that one. So in essence, it is not far off to try to view a condominium building as sort of like a company or a corporation, and the unit owners are essentially the stockholders or the shareholders of that company. And for so long as you own the shares in that company, you can do what you want in that company, subject to the rights of your fellow unit owners. So, ang nangyayari kasi before is that condominium corporations have to renew their documents with the SEC so that their legal life can be extended beyond 50 years, or they'll be given another 50 years. But it is essentially the problem of the condominium corporation, and even assuming that the condominium corporation somewhat forgets to do that during the prior versions of the corporation code, as a unit owner, you still own that. Ang magkakaproblema lang would be essentially wala nang ma-manage ng mga common areas, the hallways, the facilities of the building. So to answer your question, there is no such thing as perpetual ownership. I think another situation wherein that word is being bandied about is with respect to the parking slots
Mhm.
that you buy with it. There are certain variations again in the industry as to how that is. Some real estate companies have a separate title for the parking slot, and when you buy a unit with a parking slot, they will essentially give you two titles. One is the certificate of title for the unit itself, for the condominium unit, and a certificate of title for the parking slot. Sometimes it is appurtenant. In essence, there's no separate title. Tapos ang sinasabi lang nila, you have perpetual right over the parking slot. In essence, hindi na nila inano yan. But these are just legal variations on how to go about the concept of tackling how to handle parking slots and everything like that. So again, that's another potential area wherein this word perpetual ownership has cropped about. But in essence, that's how it is. Now, you earlier question as to whether or not foreigners can actually own condominium units. So, yun na nga, sa amin as primarily a developer of condominium units, hindi namin nagiging issue yun. So we can sell to foreigners. Ang nagiging concern lang, and it is actually the lookout of real estate companies, is that we make sure that we limit the number of units that we sell to foreigners to no more than 40%, so as not to violate Philippine laws. So that in essence, kasi again, if you think of a condominium corporation as a company, then that means you limit the ownership of that company to 40% foreign ownership so that you can remain compliant with national laws regarding condominium units. So that's basically it. Perpetual ownership, it is best to actually demand a title to a condominium unit. That's your single best proof of ownership to your hard-earned real estate property.
Thank you, Attorney Gani. Dean, would you like to add?
I think that that concept of perpetual ownership of 50 years, came into being because there was a provision, there are certain provisions in the Condominium Act that talk about 50 years.
Years, yes.
I think that is the reason why people are talking about 50-year perpetual ownership. Some people would like to think that when you say 50 years, hanggang 50 years lang yung ownership. Now, let me just share with you basic provisions, no? Just to show you that it really doesn't mean that your ownership is
It's still limited to 50%.
Yes, to 50 years. When we speak of, I'm now referring to Section 8 of the Condominium Act. It says it here, where several persons own condominiums in a condominium project, an action may be brought by one or more such persons for the partition thereof by the sale of the entire project, as if the owners of all the condominiums in such project were co-owners of the entire project in the same proportion as their interest in the common heirs, provided, however, that a partition shall be made only upon showing, and let me just go to letter C, that the project has been in existence in excess of 50 years, that it is obsolete and uneconomic, and that the condominium owners holding in aggregate more than 50% interest in the common heirs are opposed to repair or restoration or remodeling or modernizing of the project. So basically, when you read these provisions, you're actually talking about, for example, this one has been explained for and it's obsolete and uneconomical. So what does that mean? It only goes to show that when you talk about that 50-year period, you're talking about whether it's going to be economical to maintain the condominium project, considering that it has already been in existence for 50 years and nobody wants to put in money to restore it, to make it habitable. So at least the law gives, a way out. They can all agree and sell it and partition it if the condominium unit is no longer habitable. But it doesn't mean that when you use the word perpetual ownership, it is limited only to 50. No. you own it. You own it. Nobody can tell you that you can own, unless of course that is a provision in the agreement that there's a limit as to the ownership. No. But other than that, if there's no limitation, when you bought the property, there's no limitation imposed in the contract, then that you own that. You can die there if you like, okay? You can have your 75th birthday there if you like, provided that the condominium unit is, of course, still viable and not obsolete. Okay, that's it. Thank you.
Okay, this is for the buyers naman din, and Attorney Gani. In the event that not all features or amenities that were shown to me during the pre-selling stage, can I sue or can I ask for a refund from my developer?
Should I go first, Attorney Mawis?
Well, it will be used against you. It will be an admission against interest. Please go ahead.
Yes. Well, I hope my bosses are not watching this webinar, but yes, essentially. But that again assumes that there are certain facts in place. Let's say, for example, what do I say? If the real estate brokers that you were talking to who are legitimately connected to the real estate development company whose project you're looking at, and there were actually flyers, brochures, pictures, things like that, or advertising material that clearly promised certain facilities, and these materials were not made by some broker without the consent or knowledge of the real estate development company, but rather are marketing materials, brochures that were actually put out by the company for use by the real estate brokers, and you relied on those materials, and that swayed you into buying a condominium unit there, and then later on when it's turned over, it's not there, or the unit that you're buying has certain features that were clearly promised to you through those advertising materials by the company through the broker, then yes, you can. You can. uh, but as I said, why do I say it in that way? uh, it's uh, it's because we cannot stop certain people from misrepresenting certain things, diba? So again, it goes back to the basic fundamentals that Attorney Mawis began. Make sure that you're talking to a legitimate broker, so that more or less you will be assured that he is speaking correctly for or in behalf of the property owner or the property developer that you're eyeing. So, kasi pag ang kausap mo naman is some broker with shady connections, and he promised you the moon and the stars with respect to this condominium, and later on it's not there, then you might not be able to go after the real estate development company, because the company will just say, or we will just say na, well, you talked to the wrong person. He is not actually legitimately connected with us. Diba? But in a situation wherein the company itself promised such features of the unit or of the project through their materials, diba? And you heard it from a person legitimately connected to the company, and then later on it's not there, then you can have basis for legal action against real estate developers like us.
Well, may I be allowed to speak, because I have to say this first. After hearing the answer of Attorney Gani, I feel very comfortable if I have to deal with Ortigas, because apparently the legal department of Ortigas is headed by a lawyer who is fair and just. I have to say it. Not
I will send you the materials later on.
But as I said, no, I was introduced. Actually, I'm more of a teacher than anything else. Okay, so I just by way of just providing maybe the legal basis. Again, let me refer to this slide. I would like to share. Okay, as to the liability of the developer, PD 957, which is the Subdivision and Condominium Buyers Protective Decree, provides a specific provision for the misrepresentation of brokers. No? which is particularly Section 19, advertisements that may be made by the owner or developer through newspaper, radio, television, leaflet circulars, or any other form about the subdivision or the condominium or its operations or activities must reflect the real facts and must be presented in such manner that will not tend to mislead or deceive the public. Okay, now, the owner or developer shall be answerable and liable for the facilities, improvements, infrastructures, or other forms of development represented or promised in brochures, advertisements, and other sales propaganda disseminated by the owner or developer or his agents, and the same shall form part of the sales warranties enforceable against said owner or developer jointly and severally. Failure to comply with these warranties shall also be punishable in accordance with the provision of law. I remember there was one time somebody went to me and said, the developer, they was not able to provide the swimming pool. I said, who told you? The broker. Do you have any leaflets? Showed me a leaflet. There was no swimming pool. So I said, what is the basis? Maybe it was a misrepresentation made by the broker, but you cannot attribute it to the developer because the approved leaflet does not even show even a small pool, not even a bucket of water was there, no? So how can you sue the developer? So if I were you, again to the would-be buyers, look at the leaflets, look at the brochures. That is the only thing you can hold the developer on, whatever is stated in the brochure.
Can an artist perspective tag in a photo or in a brochure save the developer from being sued? Because that's a very common practice now of most developers. They will put usually an artist perspective of the pool area, an artist perspective of the gym. Can that move actually save developers?
Okay, that's a very good question, Tech, and I'm treading on dangerous ground in trying to answer that. Right. Essentially, when you see advertising materials that say artist's perspective, yes, in essence, the potential buyer is put on notice that the real thing may not actually look like what you're actually. Kumbaga sa buyer beware to a certain extent. But what I would say would be that most legitimate and responsible real estate developers will not even allow marketing materials, even if they're artist perspectives that are so far off from what you're really planning. The reality is that in most situations, when a project or a real estate developer is already at the stage wherein you're releasing marketing materials, the plan for that real estate project, let's say a condominium unit or a subdivision, if it's a horizontal development, is more or less already, hindi naman set in stone, but more or less final with very little changes later on. Because again, it is not to the benefit of a real estate development company to engage in such practice. Because sige, makalusot kami sa isang development namin that we made such fantastic artist perspective materials. Turns out that the real thing is so disappointing. And then somehow this real estate development company dodged the bullet and is able to stave off certain legal actions filed against it because of the somewhat misleading materials. Do you think that the subsequent developments of that real estate development company will sell? Word gets around, especially in today's time wherein news, whether it's correct or incorrect, travels so fast. So it is actually in the interest of a real estate development company to come up with very, very accurate materials. When we say artist perspective, it's more, but we don't have pictures of it yet. Because we're still building it, but more or less this is what's going to happen. However, I would like to distinguish that if there is clearly a major feature there that was there in the drawing and somehow is conspicuously absent, something as innocuous as a swimming pool, then that's a different story, diba? Kumbaga sana, that's a completely inaccurate artist representation of the and there might just be basis for the buyer to sue the real estate developer in those situations.
Would you like to do a follow-up?
Basically, I think when you talk about amenities, the amenities are actually enumerated.
Yes.
And so even if you have this artist perspective, the brochure will contain a portion that would say enumerate amenities, and it will be enumerated. So if what we're talking about is the placement of the plants, you have no cause of action. But if in the amenities it says swimming pool, Olympic size, and there's no swimming pool, I think you can sue. So let's read the entire brochure. Let's not be drawn by the artist's perspective, because like what it says, it's merely an artist's perspective. Read whatever is in the fine print. I think that will be your basis of your cause of action.
That goes into romantic relationships also, Tech.
Yes, yes.
Don't rely on the artist perspective of your potential partner. And when you sign that partnership contract or marriage contract, read the fine print. So, but the point of Attorney Mao is, I cannot overstate that. She is correct. At the end of the day, if you're talking about legal action, most of the time, what prevails is what was written down. And that is something that you should really exert effort in combing through in a very detailed manner. Not just the artist's perspectives, but what is written down in the contract and, let's say, in the letter offers and such other communications.
And one to my last two questions. First question would be, what will permit the bank or the broker, or I mean the developer, to actually repossess my acquired property? I mean, in terms of delinquent payments, how many months? Is it like 3 months of non-payment would allow them to actually reacquire the property? Then what's the common practice po? And does it differ for every developer?
Attorney Gani, because he's the one acquiring the property. So I think he's the best person to answer it.
Yes, there's no hard and fast rule as to one. In strictly speaking, if you're talking from a legal perspective, one missed payment can be sufficient. For the developer to cancel the sale and try to get back the unit. But the basic rule of what did the parties agree on, then that would prevail. Since there's no hard and fast rule as to how many missed payments before the developer has the right to try to get back the unit, normally that is something that you will find in the contract. And I'm not sure if there are developers who would agree to a buyer negotiating for a different period or a different number of missed payments before, but it's entirely possible. If you're actually talking about installment payments for some other kinds of development, not just condominium units, that can be something that can be agreed upon by the parties. Again, the most fundamental thing that Attorney Maui said, what was agreed upon by the parties, even with respect to when the developer can get back the property, what was agreed upon as reflected in the contract, because that is what is in writing, then that is what will prevail. So the common practice would be, of course, 1 month. Ang nangyayari lang, Tech, is that in reality, sometimes because of specific, unique circumstances of the buyer, the developer exercises a bit of leniency and allows you to defer. But that's already going into negotiations. Now, no matter what is said in the contract, if the parties negotiate, the buyer and the seller negotiate, and the buyer and seller agree on a somewhat different arrangement from what is in writing, then that will prevail for so long as that new agreement is also put into writing and you have proof that that is what you agreed on.
But Attorney Gani, will I get any refund in the event that my property will be repossessed?
Oh, Attorney Mawis, I think that's going into the realm of the recto law.
Yeah, I think so. But we're talking
Yes.
about subdivision buyers yan, di ba?
Yeah. Ang mangyayari dyan is that I think the recto law is if you reach a certain amount of payment, I'm not too right now on the top of my head. I forget, but there is a law existing right now that once you reach a certain amount of payment, then you can probably get a portion in terms of a refund. But if you do not reach that amount, then you are not entitled to a refund.
That's why it's really necessary that before you make any investment, you are well prepared for it.
Yes.
You know your budget, you know your limits. Okay, attorney, this one is for you po, Dean Mawis. Will the properties that I acquire while I am still single automatically become conjugal as soon as I get married? Let's say I buy a property now from Ortigas land, then I get married after a year. Will that be a conjugal property?
The first question kasi that one must answer is, when did you marry? Okay, because the very important date here is, I always tell my students there are two dates which you can never ever forget whenever I teach this subject, because I teach persons and family relations. First, your birthday, okay, your birthday, and secondly, the effectivity of the family code, which is August 3, 1988. If, for example, I single, no, bought the property, let's say, before August 3, 1988, before, and we had no prenuptial agreement, then that property I bought is mine and mine alone, to the exclusion of my husband. Okay. But if I married before, okay, before, after or during the effectivity of the family code, then I bought a property, then after that I married, that property will form part of our community property, which means my husband technically is a co-owner of that property. So I'll go one step further. So how can I avoid that, my hard-earned money, I bought this property now, and then when I marry this guy, half of it will be his, and then it turns out to be a descendant of Satan. Well, how will I protect myself? Enter into a prenuptial agreement. The prenuptial agreement, okay, if it's a prenuptial agreement, it should be done before before the marriage is solemnized. Then define your property relationship and say it's either complete separation of property or conjugal partnership of gains, which means only properties acquired during the marriage will form part of the conjugal property regime. If you do not have an antenuptial agreement, then if you marry now, okay, then your husband is not only marrying you, he's also marrying your property, because half of that belongs to him already. Okay.
Sorry, but I have one final question. This one is actually a phone-in question. In the event that I invested in a property, then for some unforeseen reason, I got sick and died, will that property be forfeited because it's not yet fully paid?
No, I'm sorry, I don't think, no. As long as as long as you're not in default, okay, as long as there's already a property right which is transmissible upon death, okay? So technically, it can be transmitted, then the heirs can just continue paying.
Pero din in the event that they don't want to pay or they don't want to
property.
The property.
You can might as well say goodbye to the property, because the contract will, with the contract provisions, especially on the default provisions, may apply, and you might lose the property.
Mhm.
In essence, Maui, what will happen would be that you entered into a contract with a real estate developer for a property, whether it's land or it's a condominium unit. And supposedly you need to pay it off a certain number of years before it eventually becomes completely yours once you pay the amount in full after your amortization schedule. And at some point while you were still paying for it, you passed away. Will that property pass on to the heirs of that person who died? Well, what passes on to them would be the obligation to pay the balance. If the payments have already reached a point wherein you're entitled to a refund, then of course, then the right to a refund, of course, will transfer to that. That may seem unfair, but you have to look at it also from the perspective that whatever payments the person who died have already made before his death also actually benefits his heirs kasi nabayaran na nila yon eh. What you will only deal with the balance. In theory, if the person's estate, the remaining property of the person who died is more than enough to cover the remaining balance of any unpaid property, then that can be used to pay it off. And once that paid off, then essentially that property is now owned by the estate of the person who died, and that can be part of what is can be inherited by the people he or she left behind.
Thank you for that, Attorney Gani. Before we hear the final thoughts from our panelists, I just have one more question. In the event that I acquire the property and I cannot anymore pay for it, can I transfer it to another possible or potential buyer? Or do we need to first get in touch with our developer? Or can we do it by ourselves? Do I need to inform the developer ahead?
Actually, it will be governed by the contract between you and the buyer.
Yeah.
There are some developers that imposes a condition
Yes.
that if you are not yet paid, okay, you cannot sell the property without their consent. So to my mind, first again, check the contract, what is in the contract. Okay, because otherwise, or there are some developers that would impose an additional condition, no, to the would-be buyer of what to pay. Okay, like transfer fees, for example. Okay, so check your contract first, because remember that when you have a contract, that is the law between the parties.
Attorney Mawis is correct, actually. It will be a case-to-case basis. Different real estate development companies may impose different conditions in the situation that you're talking about. But in most cases, I would imagine that a lot of real estate development companies would want you to get their consent first with respect to the particular person that you plan to transfer your obligations to. Especially if the buyer or the person transferring you want to transfer it to might be a foreigner, because as Attorney Mawis actually said before, as real estate developers company, we have to be conscious about it. We cannot sell more than 40% of a condominium unit to foreigners. So if you're planning to transfer to a foreigner, but that particular development has already been sold and we've already reached the 40% maximum, then the person you're eyeing might not be allowed. So, and again, other specific conditions that may be found in the contract. So yeah, Attorney Mawis is absolutely correct. Read the contract.
That was such a great discussion, highly informative and helpful indeed. Unfortunately, that's all the time that we have left for today. But before we officially close this webinar, may we hear some final thoughts from our panelists? Maybe Attorney Mawis can start, followed by Attorney Gani.
Okay, just give me about just a minute and a half, because I would like to read this. This is really a statement of the Supreme Court, and it will really guide all of us. Okay, allow me to share just very briefly. Okay, this is actually a statement made by the Supreme Court in the case of Villa versus Valles. It was promulgated sometime in 1916, if I'm not mistaken. But this rings so true even today. All men are presumed to be sane and normal and subject to be moved by substantially the same motives. When of age and sane, they must take care of themselves in their relation with others in the business of life. Wit, sense, intelligence, training, ability, and judgment meet and clash and contest, sometimes with gain and advantage to all, sometimes to a few only, with loss and injury to others. In this contest, men must depend upon themselves, upon their own abilities, talents, training, sense, acumen, or judgment. The fact that one may be worsted by another of itself furnishes no cause of complaint. One man cannot complain because another is more able or better trained or has a better sense of judgment than he has. And when the two meet on a fair field, the inferior cannot murmur if the battle goes against him. The law furnishes no protection to the inferior simply because he is an inferior, or any more than it protects the strong because he is strong. The law furnishes protection to both alike. to one or more or less than to the other. It makes no distinction between the wise and the foolish, the great and the small, the strong and the weak. The foolish may lose all they have to the wise, but that does not mean that the law will give it back to them. Courts cannot follow one every step of his life and extricate him from bad bargains, protect him from unwise investments, relieve him from one-sided contracts, or annul the effects of foolish acts. And as I said, this was the statement made by the Supreme Court in Valles versus Villa, which was said way before. It was actually 1916. It is so true. So when you enter into a contract, please make use of your basic common sense and make sure you know the basic rudiments of the law, because like what Ted said earlier, ignorance of the law excuses no one from compliance therewith. Thank you very much.
Thank you, Dean. Now may we hear from Attorney Gani. Attorney Gani, I think you're on mute.
Buying real estate need not be a scary proposition. It is a very, very big step that most people would take in their lives. And for sure, as a result of that, you really need to take care and, as Attorney Maui said, use a lot of common sense when you go into that. But not everyone is out there to hoodwink you. As Attorney Maui said, the law will not protect you if you do not try to protect yourself and be as knowledgeable as you can be before entering into that kind of transaction. But the very first step would be to really look at the company that you want to deal with, or in the case of private property, the person who you will be dealing with. If that person has some basic sense of decency, or that company has a good reputation, it probably earned that reputation by being fair to the people it deals with. So stick within your budget, but get the most out of your money that you're willing to invest. Take it one step at a time. Do not be scared to ask questions, because in the process of asking questions, you might actually find out if the people that you're talking to or you're trying to deal with actually do care for you. And if they do care for you, then it might just turn out to be a good deal. And the joy of having your own house, the joy of having your own condominium unit is something that is really to be cherished. So buy wisely, but don't be too scared. Go out and invest, because it's really something that you will enjoy in the future.
Thank you. And that wraps up our webinar for today. I hope you learned a lot today, as I know I did. Thank you to our panelists for sharing their time, their insights, and expertise with us, as well as to Ortigas Land, our partner for this webinar. I'm sure we've had many of your questions answered, but if you still have more, do check out the property section of the Philippine Daily Inquirer, which comes out every Saturday, and look for property rules. Again, this is Texa Maniego. Thank you and good day to all.